All right, welcome to your Exam Prep Explainer. Today, we're going to absolutely master the core agency concepts you need to know to pass your Florida State exam.
Okay, let's just dive right in. With a situation you will definitely face. A seller wants your complete, undivided loyalty, but then an unrepresented buyer calls you about the listing.
This is the core challenge right here. How do you handle this? How do you navigate this whole thing without accidentally violating Florida law? I mean, your license literally depends on getting this right.
Okay, a real pro knows the playbook, and it goes like this. Step 1, you immediately provide the buyer with the no brokerage relationship notice. Step 2, you operate as a single agent for your seller, giving them all those fiduciary duties. And Step 3, you treat that buyer, who is your customer now, with total honesty and fairness. So let's break down the tools you're going to use to pull this off.
You know, in Florida, the law has a default setting. It presumes you're a transaction broker unless you put something else in writing. Understanding these three options isn't just a good idea, it is absolutely non-negotiable.
So what's really interesting here is the fundamental difference between these two. A single agent, you're an advocate. You're in their corner. A transaction broker, you're more like a neutral facilitator, a referee for the deal. Exam alert. Okay, lean in for this next slide. I can practically guarantee you will be asked to tell the difference between the duties for all three of these relationships.
And this chart just lays it out perfectly. Look at how the duties escalate. It's like building blocks, right? Each level builds on the last one. You start with the basics for no brokerage, then transaction broker adds a few more, including that huge keyword, limited confidentiality. And finally, the single agent. That's the whole shebang, with full fiduciary duties.
Okay, let's move on and see how this all connects. We're heading into the terminology vault. Knowing these precise definitions, this is how you score those easy points on the exam.
Fiduciary. If there's one word you need to burn into your brain, it's this one. It is the absolute highest standard of care. It's a promise, a promise to put your client's interests above everyone else's. And yeah, that includes your own. You're basically a trusted guardian for their interests.
Next up, caveat emptor. It's Latin, sounds fancy, just means let the buyer beware. But, and this is a big but, while Florida is a caveat emptor state, it's not a get-out-of-jail-free card. You still have a duty to disclose any known material facts that could mess with the property's value.
So this one is critical. Dual agency, it's just flat out illegal in Florida. You simply cannot be a fiduciary, an advocate for two opposing parties in the same deal. The conflict of interest is it's unavoidable.
Okay, so what if you start out as a single agent for a seller, but then you're the one who finds the perfect buyer? Well, this is where the consent to transition comes in. Think of it as your legal permission slip. It's the written, signed agreement you absolutely must have to switch your role from a single agent to a transaction broker.
All right, now for my favorite part, and probably the most important part of this whole prep session. Let's diffuse some of the common traps the state exam is going to try to set for you.
Look at this question carefully. They're giving you a very specific list of duties. An agent owes a customer honesty, skill, care, and limited confidentiality. So what's the key phrase in there? What's the one thing that just gives away the answer?
The answer is, of course, transaction broker. And the trap is including honesty and skill and care because, well, multiple relationships share those. The unique identifier, the magic phrase you're looking for, is limited confidentiality. That is the dead giveaway for a transaction broker.
And here's another one they love to use. They're asking about the written disclosure forms. Which relationships require you to have one of those up front before you even show a property?
The answer here is single agent and no brokerage. And the trap, the thing to remember, is that transaction broker is the default. It's the presumed relationship. So you don't need an initial form for that one. You only need the form for the other two when you're establishing something different.
All right, let's lock this all in. If you walk away with nothing else, you need to burn these 3 points into your memory for exam day. This is your 60-second cram session. Number 1, the 3 relationships. You have got to know the duties for non-representation, transaction broker, and single agent. Know them cold. Number 2, fiduciary means ultimate loyalty. It's that highest standard of care. It means loyalty, obedience, and full confidentiality and disclosure, and it's only for a single agent. And finally, number 3, disclose and document. Use the right written notices for single agent and no brokerage, and always get that consent to transition in writing. Okay, that's your prep for today, but to keep your mind sharp for the exam,
think about this final question. It's a good one. Good luck with your studies. You're going to do great.